Good morning, everybody who's joined so far. My name is David Geral. Welcome to Breakfast with Benefits. We are waiting for a few people to join, so we'll give it a couple of minutes, and I think I will try and start at 8:33. So we'll get going then. Okay. I think it's best we start. We have quite a full agenda. So good morning. Welcome those of you who've joined so far to, I think this is the first Breakfast with Benefits of 2022. We're sneaking it in just right at the end. My name is David Geral. Some of you may know me. I'm a partner at Bowmans in our employee benefits practice. I head up our financial services regulatory team. I'll be hosting the Breakfast with Benefits today and introducing speakers, etc. I'd like to quickly run through a few housekeeping matters, which will hopefully enhance the webinar experience for all of you. As participants, you are all automatically muted, and the chat functionality has also been disabled, so don't spend too much energy on the chat function. If you have any questions during the webinar, please use the Q&A team. The Q&A tab at the bottom of your screen. Your questions will come through to me as the facilitator, and I will kind of moderate and select a few. I will identify the themes that seem to be resonating with the audience, and raise those with the panel at an appropriate time during the webinar. We will not be providing written responses to questions, so please don't expect that. And the webinar is being recorded, so please do note that if it raises any concerns for you. But the upside of the recording, of course, is that a copy will be made available on our website later today. And our website is www.bowmanslaw, that's BOWMANSLAW, all one word, .com, not .co.za. So the speakers today, I'm obviously the first speaker, and I suppose I should explain that I'm having a bit of a webcam problem on my side. So I haven't had any complaints yet about anybody not being able to see me. So that's unsurprising, but I've put up another picture instead. You won't see me during the course of today's presentation, but you will certainly be seeing the other presenters. So I'm sorry about that. Our first speaker, or our first speakers rather, will be Deirdre Phillips and Aneria Bouwer of our tax practice, who will be discussing some aspects of the two-pot retirement system that has made a lot of news recently for good reason. And then they'll take you up to about 9:25, at which stage I will step in and discuss the case of Maropa and others versus the Chemical Industries National Provident Fund, which raises a few quite interesting takes on the law. Then after that, we'll hand over to Damant, who will give a case update on Living Hands versus Old Mutual, which, although not directly a pension related case, certainly is a very impactful matter within the general benefits space, and has some important lessons, I suppose, thinking points, certainly for asset managers. Deirdre will then return after Graham to give us a case update on the Municipal Employees Pension Fund versus Mudao and another. And then finally, Deirdre will close the session after her last presentation. So without any further ado, I'd like to thank Aneria and Deirdre for taking the next session, and hand over to them.
Good morning, everybody. Thank you so much, David. So I'm going to go straight into it because we have limited time and a lot to say. I just want to share my screen. See if I can do this. I assume everybody can see it, David?
Yes, looks good.
Okay, so as David said, we will be discussing the two-pot retirement system today. There's a lot to say, so I hope we can say enough within the 45 or 50 minutes we have. I'm co-presenting with Aneria, our expert in taxes, as David has said, and she'll cover later on a few of the tax implications. So what I'm going to do is I'm going to provide a high-level overview of the proposed changes to the Income Tax Act, the recent responses National Treasury put forward following the public comments that was received, and then more importantly, I'll be unpacking some of the issues we have come across in understanding the two-pot retirement system. So as you may know, the draft Revenue Law Amendment Bill was published by National Treasury on the 29th of July this year. It's that draft bill, not a final bill, but that draft bill that contains the amendments to the Income Tax Act that introduces the two-pot retirement system. Public comments were due on the 29th of August, so we were given like a month to comment on it, which is quite surprising given the extent of the amendments, but be that as it may, that's what we were given. National Treasury then held a workshop on the 12th of September to discuss the draft bill. We, Bowmans, attended that session where we provided some of our feedback. Then National Treasury presented its response to the public comments received before Parliament on the 20th of September. And you'll see in our presentation where I've highlighted in gold, not necessarily blue, gold bits or orange bits, that is National Treasury's response. That is not yet, in the draft bill as was published, but it's insightful for us today to see what National Treasury's thinking is following receipt of public comments. So it's very important for purposes of this discussion that we bear in mind what National Treasury's policy intent was by publishing or introducing the two-pot system. It said in the explanatory memo that was published with the draft bill that the following two concerns it wishes to address, and that is the inability of households in financial distress to access the retirement savings prior to withdrawal or retirement, and the failure to preserve for retirement when members withdraw or resign. As we know, members access their funds. So you may have seen that when COVID just hit, there was lots of, especially the labor organizations that have pushed for immediate access to retirement savings because, the world, us, were in financial distress and needed some savings to help. And therefore there was a push to access some of the retirement savings that was locked up that is locked up in a fund before a member resigns or retires. But of course, we know that the current laws provides that only in certain trigger events will a member be entitled to access their benefits, and that is either upon retirement or withdrawal, or in the event where the member passes on death. Similarly, when a member of a preservation fund or a retirement annuity fund may only access their funds upon retirement. But as we know, a provident preservation fund members are entitled to a once-off withdrawal benefit. So just want to go to the next slide. So what the two-pot system then proposes, initially the draft bill said that with effect from the 1st of March 2023, we now know that it's been changed to, or National Treasury agreed to a further implementation date of March 2024. So it postponed it with a year. Whether a year is sufficient, as I'll discuss later this morning, is to be seen. I personally think it's very ambitious, given all the amendments and the knock-on effects the two-pot system will have on the industry. But let's see what's going to happen. So for all intents and purposes, National Treasury agreed that they'll postpone it to 1 March 2024. There will be, I don't know why it's called the two-pot retirement system, because as a matter of fact, there's actually 3 pots. It's the savings pot, the retirement pot, and the vested pot, which I'll unpack later, that will be introduced. And this two-pot or the 3-pot retirement system will apply to all funds: pension, provident, preservation, annuity, including defined contribution funds and defined benefit funds, and then also hybrid funds will be affected by the two-pot retirement system. So if I go straight into the pots, I've put out in the slides, and I can make my slides available for those that wish to have access to them, what will be in and out the pots. So in the savings pot, we know that not more than 1/3 of a member's total contribution, excluding charges and risk premiums, must be deposited in that savings pot. When the draft was published, there was discussions whether it can be less than 1/3, and whether members may have a choice as to whether they wish to have 1/3 in or less than 1/3, and the administrative nightmare for trustees in their rules to decide, you know, what portion of the contribution should be allocated in the savings pot. But National Treasury clarified that all funds must provide for a savings pot in their rules, and that the 1/3 of the contribution must be paid in the pot. So not less than 1/3 will be permitted to be paid. So that's essentially what goes into the savings pot. Out the savings pot is a new definition that has been added to the Income Tax Act, which is known as the savings withdrawal benefit, which a member may take, and it is not less than 2,000 Rand that may be withdrawn in any 12-month period. There was talk and misinterpretation initially where some people thought that you can only take out 2,000 Rand within a 12-month period. That's not the case. The draft bill refers to not less than 2,000 Rand, and there's currently no cap on what may be taken. So from 1 March 2024, whatever, you know, that part of that 1/3 contribution that will be paid into the savings pot may be then withdrawn, you know, going forward. So potentially you can withdraw everything from the savings pot, depending on, you know, what you've put into that pot. As Aneria will discuss later, members will be taxed at normal retirement tax rates if they withdraw or tap into their savings withdrawal benefit. There's no conditions when you want to deduct from the savings pots. So a member does not need to have retired or resigned. And that is, you know, talks to National Treasury's policy intent, where they're trying to assist members that may be in a financial distress situation, that need access, but that they don't necessarily need to retire or resign. And then what also will go out the pot is where if a member has available funds on retirement, then he or she may choose to transfer that balance into his or her retirement pot, or may withdraw the balance in cash. The draft bill also refers to what may go out the pot is on death or retirement, the value in that savings pot will be deemed to be paid to a nominee or dependent of a retired member as a lump sum benefit. And if there's no nominee or no dependent, then that will be a payment into the estate. I'm just pausing here to say that I find it quite interesting that the draft bill only refers to death benefits when it comes to the savings pot. Nothing is mentioned in relation to the retirement pot. So while the savings pot has been singled out is not known to me. And it's also interesting that reference is made to that if there's no nominee or dependent, that will be a payment into the estate, where we know in terms of Section 37C, there has been discussions and cases where you can donate money or a death benefit to some charity or, some, other organization. So this is quite prescriptive in what needs to take place. What may also go out the pot is where a member is a member of two funds, he or she can transfer the balance in a savings pot to another savings pot in a retirement fund, and that transfer will be tax-free. So again, the gold bits, National Treasury clarified that 12-month period because there were lots of questions and said it's a rolling 12-month period. That 2,000 Rand minimum amount is the gross amount. And National Treasury seems to have accepted that if members have less than 2,000 Rand in their savings pot, then on exit or on termination, that they can access that full amount. Going into the retirement pot. So what may be in the retirement pot is not less than the 2/3 of the available contributions. And as is the case with the savings pot, that contribution needs to be calculated excluding charges and risk premiums. What can also go in the retirement pot is the transfer of available funds from a retirement pot in another fund. So in each instance, if you have a savings pot in one fund, you can transfer to a savings pot in another fund, retirement pot into another retirement pot. That seems to be the theme right across. Then out the pot will be, you can only withdraw from that pot on normal retirement age, and the total value must be paid by the fund in either annuity form, a living or a life annuity, or a combination. So this again talks to the policy intent where it's made clear that, or forced, and National Treasury's policy of preservation, forcing members to save for retirement. So the available balance in the retirement pot will only be made available when they retire. So if the value is less than the proposed minimum, the de minimis amount, which is 165,000, then that can be taken as a cash withdrawal. You don't need to go and buy or the fund doesn't need to provide you with an annuity or a monthly pension. That can be taken in cash. National Treasury also clarified that the policy intent of the current de minimis amount applies on a cumulative basis per pot. So not to be clever and thinking that the cap applies to 165 in the savings pot, vested pot, or retirement fund, or the retirement pot. It's a cumulative basis and not per pot. And as I've mentioned, transfer from one retirement pot to another retirement pot will be permitted. What may not be taken from the pot, as I've already mentioned, is that it cannot be taken before a member reaches his or her normal retirement age. And that age depends on the rules of the fund, whether it's 60, 65, 62, it depends on the rules. Interestingly, some of the comments, the public comments that were received is where National Treasury was again asked, well, can we please access our benefits on resignation or retrenchment? And of course, National Treasury won't agree, I don't think, because it defeats the whole purpose that a member cannot access it on on resignation, but they are thinking about when a member is retrenched. And the thinking behind that, it is on no fault basis to a member or an employee when she's retrenched. And in those circumstances, National Treasury is thinking, but it's not yet cast in stone, that a limited income-based withdrawal will be permitted from that retirement pot. But a withdrawal will be limited or subject to certain conditions. And these are interesting, that whatever the member has in the vested and savings pot would first need to be depleted. The member must first go and ensure that he has claimed from his UIF benefits, and that a member can prove that there's no other source of income, alternative income, before you can then access your savings in the retirement pot from, in the event of retrenchment. And then to add another condition, National Treasury said that it will be for a limited period and it will be paid in a form of an annuity with a maximum amount per year. Now, I feel sorry for trustees of funds that need to go and test, because somebody needs to test whether these conditions are met, if they are going to be in the final bill, that you know, how do you prove that you don't have any further income? You know, how do you prove that you have exhausted all of your UIF benefits? So additional administrative burden on funds and their administrators.
Deirdre, if I can just add to that quickly regarding the retirement pot, I think what many people did not realize when they first read about it is the give and take. Currently if you resign, then you can get access to your full withdrawal benefit. The gift that the government provided by way of the savings pot is that you can access the savings pot during the period of employment. But what they then took is that the rules are changing in respect of resignation, is that you can no longer access your pension fund saving at that date. And that's what Deirdre referred to now about on resignation, that you cannot access it, but on retrenchment, because it is no fault, there is some thought being given to that. But I think that caught many people by surprise. They saw the carrot in the form of the savings pot, but they didn't realize that the retirement pots will effectively have to be annuitized eventually on retirement.
Yes. So whether this is going to be in, I'm not sure, but it's an interesting proposal or comment from National Treasury. So the last pot is the vested pot. So what is in the pot is basically all of the contributions, the value of your current fund credit as you have today, as an example, will be in the vested pot, although whenever the legislation will kick in, which is now proposed, as I've mentioned, the 1st of March 2024. So funds would then need to go and assess what the value of your benefit is the night before, on the 29th of Feb, and that will be in the vested pot, and that will be grandfathered, meaning whatever rights and obligations, and it's important, and I'll discuss it, it's right and obligations you may have in relation to your benefit currently will be grandfathered. But we'll deal with the seeding capital a bit later on. So what's also in the pot, you can also transfer from a vested pot to another fund, you know, as I've mentioned before, from one vested pot in a fund to another vested pot in another fund, and that will also be tax-free. What may not be in the pot, so you may not make further contributions to the vested pot, except if you were a Provident Fund member and you were 55 years on the 1st of March 2021. And for some of you, you may know that that's when the annuitization kicked in. Out of the pot, the value of the vested pot will be subject to whatever your current conditions are, as I've mentioned. So for example, where members may not currently, before resignation, tap into their benefit, that will apply to that vested pot. And as I've also said, you can transfer out the pot. Similarly, you can transfer from one vested pot to another vested pot in any of the funds mentioned. Other comments and responses by National Treasury is that they've clarified that it's mandatory. Some commentators were, you know, saying that, you know, it can't apply to, for example, a defined benefit fund. They've made it clear that it does. Some of the comments were whether the same investment strategy a fund currently has would need to apply to each pot. And what happens with the Regulation 28 compliance in relation to each pot. And National Treasury, to no surprise, said, well, it's not a tax issue. Please discuss that with the FECA. So we'll have to wait and see what the FECA says in relation to how a fund's investment strategy and Regulation 28 conditions will apply to each of these pots. I personally think it's going to potentially be quite a nightmare, but we all clever people, we will make it happen. the policy intent, some of the questions were also, what about the members that were Provident Fund members and were 55 years or older on the 1st of March? What happens to them? Because they currently have their vested rights. And National Treasury said that perhaps an option will be made available to them where they will choose either to participate in the two-pot system, or they can continue contributing to the vested pot, subject to the condition that they remain a member of the same fund, which I think is a bit problematic, because what happens if the fund is liquidated, if the fund is transferred to another fund, what would happen to your rights then? National Treasury also said that the policy intent for the vested pot is to be an accumulation of all vested and non-vested rights earned prior to the implementation of the two-pot system. Lots and lots of comments, again, I'll deal with that later, to amendments that need to be made to the Pension Funds Act and also other legislation, for example, the Government Employees Pension Proclamation, and all other states or public funds legislation would also need to be amended to accommodate the two-pot system. Specific comments were raised in relation to Section 37D deductions. So that's also in the pipeline. So just to add more on legislative amendments coming, we know we're waiting for COFI that has the consequential amendments to the Pension Funds Act, but yet again, further amendments proposed to accommodate the two-pot system. And then National Treasury also made it clear, or comments were, that pots should not be left behind. So you can't split the pots. You can't have a savings pot, you leave it in one fund and then just transfer whatever you have in your retirement pot or your vested pot in another fund. So before I go into the other juicy bits, I'm going to hand over to Aneria just to discuss the tax consequences.
Thanks, Deirdre. The income tax rate, so this is obviously the numbers part of the presentation, and the reason why we're sharing the tables is just to clarify or just to demonstrate the different tax treatment that applies to different types of benefits. So the first table there with the normal income tax rates, those are the rates that apply to ordinary income. So any remuneration or other source of income which you will receive will be subject to those rates. Those are for the 2023 tax year. And it's a progressive table. It starts at 18%, and then a marginal income tax rate of 45% applies to taxable earnings in excess of 1.73 million. And the relevance of this table is that the proposal is that for withdrawals from the savings pot to be taxed at normal income tax rate, and I will deal with that on the next slide. But also these contributions to retirement funds are claimed as a deduction, which has got an impact on your normal income tax. So that means if you are a high income earner and you claim contributions to a retirement fund, which could include a pension and provident or RAF, then you could have a tax saving of about 45%. Then, with respect to retirement fund lump sum withdrawal benefit, if you, on termination of employment, decide to take the cash in your retirement fund, then there is a special table, but you will see that it is more beneficial than the normal income tax rates, but not as beneficial as in the last table, which is the retirement fund lump sum benefit. So on withdrawal, and with respect to the last two tables, these are lifetime tables. So this is not an annual table. So for example, on retirement fund lump sum withdrawal, the first time that you withdraw from a retirement fund, your first 25,000 Rand will be taxed at 0%. Then the next bracket up to 660,000 will be taxed at 18%, then 27, and then 36% in excess of 990,000. So if you have already withdrawn from a fund before and you've already received 990,000, then the rate applicable to future withdrawals will be 36%. The retirement fund lump sum benefit table has got the same rates but different brackets, and this is substantially more beneficial. Your first 500,000 Rand is taxed at 0%. Then the 18% bracket is smaller than what it is for the withdrawal benefit. Then your 27% bracket is to the amount between 700,000 and 1,050,000. And then amounts in excess of 1.05 million is subject to tax at 36%. And it's also just important to keep in mind that that last table applies cumulatively over your lifetime, not only in respect of retirement fund lump sum benefits, but also severance benefits. So for example, if you were retrenched, etc., that would also have chipped away from this table. So the question then is, if we can move on to the next slide, is which rates would apply to the different types of benefits. So firstly, just with respect to contributions, the rule currently is that a taxpayer can claim a deduction of contributions to a retirement fund, and thankfully this has been streamlined and we no longer have the different deductions for pension and provident fund and retirement annuity funds. But there's a cap for all contributions to retirement funds of 27.5% of taxable income, or 350,000 Rand per year. There was a proposal in the draft TLAB that contributions in excess thereof should be allocated to the retirement pot, but that's a huge practical problem. For example, a retirement annuity fund will not know what amounts have already been contributed, etc. So Treasury seems to be walking away from that proposal. Then the more controversial proposal is in respect of the withdrawals from the savings pot. So that is the 1/3 of contributions which will go to the savings pot, which a member can withdraw a certain amount, not less than 2,000 Rand every 12 months. And these, no commentators referred to the member having to show that they are in financial difficulties, etc. That's actually not a requirement. That is just like money in a bank account. You can withdraw from it at any stage, but it will be subject to normal income tax rates. So the rates that were in the first table with a maximum rate of 45% will apply to that. The members will not get the benefit of the withdrawal tax table. And it is more onerous than normal withdrawal benefits. But Treasury is concerned that there could be, for high income earners, a differential if they claim a contribution and they get a benefit of 45%, and they then withdraw and they get the benefit of 36% in the withdrawal tax table, then there's a 9% tax saving. Also, the intention with withdrawal from the savings is, or from the savings pot, is that members will withdraw from it at a time when they have lost other sources of income. So for example, if you have lost your income and you normally earn R1 million a year, and now you've lost all of that income, if you then withdraw from your savings pot, then it will essentially replace that income which you've lost, which should not result in a higher income tax rate than normally. So that's the one argument. To the extent that you have not lost a source of income, but you still choose to withdraw from the savings pot, there's almost a kind of a punitive element to it. You do have access to more income than is normally the case. and Treasury realizes that the member will in those circumstances pay income tax at a higher rate. I don't think they're going to budge on that. There were lots of criticism saying that it should not be subject to the normal income tax rates, but because of the sense that withdrawal from the savings pot should either replace income that you've lost, or if it's extra, Treasury doesn't want to encourage people to withdraw from the savings pot. Ultimately, they still want those funds to remain available for retirement. So I don't think we're going to see any changes to that. Just with respect to the Q&As, I saw there was a question as to whether or not the two-pot system will also apply to retirement annuities. And the answer is yes, it will apply to all types of retirement funds. Deirdre, I think I've actually already dealt with this slide, so we can just move on to your slides again.
Thank you, Aneria. Lots of tax considerations. So I'm going to go into some of the more controversial comments that were made, and I quoted one where it was said that the lack of access on the implementation date will result in workers resigning and members still seek immediate access. Some of the labour organisations have proposed that the implementation date rather be October 2023 and not the 1st of March 2024. And there's still some commentators that are insistent that due to financial circumstances that immediate access be given. So National Treasury is, as I've quoted there, they're considering seeding, and it's said that it's open to a once-off seeding capital as long as it does not have adverse implications on liquidity of retirement funds, and the cost of such withdrawal is not imposed on members choosing not to withdraw. The mechanism to enable this will require consultation with commentators, which I find interesting, not stakeholders at large, to take the relevant risks and benefit into account, as well as possible trades off on invested rights. So my views on that is, first, when will seeding be permitted, if that is going to be the final decision? Will there be, what requirements will be attached to it? What amount can be taken? Will there be a cap? Probably. Will the vested pot fall away if members access their retirement savings in advance? Probably. Will there actually be real advantages to members if seeding or immediate access is available? So I understand the financial difficulties that COVID has brought about, and that members may be in financial distress and that they need capital, or they need a cash injection to, I don't know, pay off debt, to survive, to eat, to pay off loan sharks, and not to go into deeper debt. But one would need to think of whether a once-off access, if immediate, as opposed to, you know, an annual access to the savings pot, will make such a big difference. And one would also need to think of the disadvantages to members, and not only members, the industry at large, the retirement funds, all other stakeholders, if seeding capital will be permitted, or if, you know, immediate access to a portion of the current retirement savings will be permitted. My view on that is that I think the disadvantages far outweigh the immediate advantage. Although there are the threats of workers resigning, and those have been threats since COVID started, you know, lots of members haven't resigned. You know, we in a country where unemployment is, I think, the highest in the world. So I don't think that may be a real threat, but we, you know, you'll never know. The cost also needs to be taken into account. So retirement funds and administrators would need to do a lot of work in implementing the 2-pot or the 3-pot system. I might just mention that there's discussions in renaming the renaming convention, that it's actually not called pots or not called a retirement pot or a vested pots. There's talk about renaming those pots, but I think we've now become accustomed to the retirement savings and vested pot. What is important is that we, as I've mentioned earlier, that we need to go and look at the policy intent, and it looks like government or National Treasury may be stepping back, in my view, with the policy intent, which was that members need to preserve, we need to preserve for retirement. So if seeding or once-off or immediate access is made available, when those members do retire, it may have consequences when they eventually retire, that they may become a burden on this. So whether the lack of or whether seeding will be permitted is to be seen, and whether it's actually beneficial is also to be seen. My view is that it may not necessarily be. So a few practical considerations, just lastly, in taking all of the 2-pot retirement system proposed amendments into account, is the bigger Section 37D issues. We've received a few queries on that already. As just to recap, and as should be known, is that 37D makes provision for certain permissible deductions, and that would be divorce, where an employer has a claim against a member's benefit in the event of misconduct or fraud, whether the employer suffers damages as a result of the employee. Maintenance deductions is also permitted, and then housing guarantees, or where the fund either is the credit provider, where there's actually not a lot of those, or where the bank is the credit provider and the member's benefit is used as surety. So if you can deduct, if the savings pot as currently proposed, or even if immediate access will take place, the questions are, but what about those? What about the Section 37C, Section 37D deductions? Who has first rights on those benefits? If there's a pending divorce, or if the employer has a pending claim, or if there's a maintenance obligation, whether it's future or arrear contributions, or even if there's existing housing guarantees, must those creditors then first be paid? Will they have first debts on that money? And then also, does the fund have an obligation to notify those creditors that, for example, a member wishes to withdraw from the savings pot? This, because it may potentially impact, if you just use an employer as an example. If the employer has a damages claim, and the available amount will be depleted because a member can tap into the savings pot, is there a positive obligation on the fund then to notify the employer? Or will the employer have first right to have his or to have its benefit or damages claim paid? So those are a few questions that have arisen. Whether those questions will be answered in the draft amendments to 37D that's proposed is also to be seen. I think 37D will be reworked totally. Then if you take into account what we've known for many decades, that the contribution in a fund it's not the member's money. It's a member only becomes entitled to a benefit provided in the rules on certain trigger events, as I've mentioned, retirement, resignation, or death for their beneficiaries. Now, if a member is entitled to access monies from the savings pot without the need to retire or without the need to resign and without any conditions attached to it, have we then now changed the law in relation to accrual. Does that then mean that contributions paid into a fund then actually belong to a member? Because as I've said, and there's plenty of cases that, the assets of the fund belong to the fund. As the two-pot system fundamentally changed how we understand accrual and your rights to benefits. Lots of questions have also been asked in relation to Section 14 transfers and how that will work when this is implemented. How will you transfer the various pots? And I would think that, as National Treasury has made it clear, and from the wording of the draft bill, is that it will apply to all funds. So all funds would need in their rules, to have the savings pot, retirement pot, invested pot. So if there's a transfer, for example, in the event of a Section 197 transfer, where benefits need to be transferred via Section 14, I would think that the receiving fund all need to have the similar, savings pot, retirement pot, vested pot to receive those transfers in. The cost of administration systems. Although National Treasury says it's their interest of preserving and that there's not enough money, on retirement, the retirement industry is flooded with lots of amendments. As I've mentioned, we have COFI on the cards. Prior to that, we had the Financial Sector Regulation Act that also applies to retirement funds, and now we have potential proposed amendments to Section 37D to deal with the two-pot system. And then, additional amendments following the amendments to the Income Tax Act. Now, all of this is going to cost money. Now, who's going to pay for it? Ultimately, it may be the member that needs to pay for this, unless the fund has some reserve to deal with legislative amendments. And some of the questions we've received is, on the administration side of things, will an administrator be entitled to tell the fund, well, sorry, you need to cover these costs for us to update our administration system to administer your fund? So I would advise that funds go and look into the current administration service level agreement to see what it says about legislative amendments and who needs to fit the bill. We also know that Section 13B says that the administrator needs to basically have everything that's necessary in order to administer a fund in receiving contributions and paying benefits. So it may be that the administrators need to fit the bill in order to administer the fund. Otherwise, they're not fit for purpose. More important considerations is the liquidity. So if the savings pot, withdrawal, or even if immediate access of a portion will be permitted, we need to think long and hard of what that's going to do to the economy. And we need to think what that's going to do to, the fund's investment strategy and the liquidity impact. Is there available cash to make those payments if everybody, or if 50% or 60% of the members tap into the savings pot or choose to make, an immediate withdrawal? What will happen to the fund? From a investment side, because we know that retirement funds are they're long-term vehicles. They're not meant to be banks. They're not meant to be treated as a transactional account where you can just simply tap into it. There's certain projections that funds need to be made. So homework would also be to probably go and consider what your current investment strategies are, and whether funds are locked into long-term investments 5-6 years from now, and whether they will be able to meet those claims. Additional considerations is communications. The employer would also need to communicate to members. Funds need to change obviously there will be rule amendments required, but member booklets, website changes, they need to go and look at all SLAs, and not only the administration SLA, but your SLA with your third party like investment managers, asset managers, evaluators. All of those need to be relooked at to implement the two-pot systems. Arrear contributions is also an interesting consideration. What happens if a member claims and wishes to tap into the savings pot, but yet we know that there's always some of those employees that, although they deduct contributions, they don't pay it over. That will have an interesting knock-on effect on whether members can then withdraw from the savings pot. Of course, as I've mentioned, rule amendments, whether the 1st of March 2024 will be a reachable or reasonable timeline, I don't think, because we know that funds need to first go and amend their rules, and before it takes effect, the FECA needs to approve it as well as SARS. So I think there will be probably a huge backlog, and we, National Treasury and the industry needs to rethink whether the 1st of March is a reasonable date. Then the last thing I just want to mention before I hand over is the benefit consulting part. We know that a couple of years ago, the PFA was amended to say that when a member goes on retirement or when a member withdraws, that a benefit consultant be made available to a fund where you discuss your various options. Now, will a benefit consultant be necessary where a member wishes to tap into the savings pot, or if there's immediate access to some of the portions, some of the retirement savings, will a fund still have that obligation to make that benefit consultant available? I think probably they would need to. So funds would also need to relook at the agreements they have with the benefit consultant, in relation to the two-pot system, and whether you want to or not convince a member that it may not be beneficial, and what the consequences are, including tax consequences, when a member withdraws from the savings pot, or if a member chooses to withdraw a bigger portion if the immediate access or seeding is made available. So there's lots of questions. My last slide on this is, we're waiting for the final bill. It's a wait and see game. As I've mentioned, only a draft bill was published. There probably will be, hopefully, a couple more iterations of the bill where National Treasury, no offense, properly takes into account the impact of this huge impact of the two-pot or the three-pot system, what it will have on the industry as a whole and members as a whole, and that we don't lose sight of the initial policy intent, and that was to preserve and not, for funds to be treated as banks. I'm going to hand over to David.
Thank you very much, Deirdre, as well as Aneria. I think, as expected, that was a significantly meaty presentation. There is a lot of information to process, and hopefully what I think you've done well, and hopefully what the audience has received is a sense of some of the questions that probably still need to be tackled. There haven't been many questions coming through on the Q&A. The one was regarding the sort of whether one can see this stuff anywhere, and the answer is that the Standing Committee on Finance has published responses, or rather a summary of the proceedings, but we're not aware of the actual submissions being made public. And the second question that was raised was whether this all applies to RAs, and in short, the question there, the answer there is yes. I wanted to remind you that there is a Q&A function, and that is the main functionality we'll be using to receive, consider, and possibly answer questions during the proceedings. But as we said, things are pretty tight. So what we're going to try and do is press on now with my presentation. I, again, just quickly want to apologize that I can't appear before you live. I'm having a webcam issue. I've managed to put a photo up of myself, which which I hope is a good thing. And I'll try and keep my voice animated. My presentation deals with a case that was handed down in June this year, which was the matter of Chris Moropa and a number of other parties against the Chemical Industries National Provident Fund. And the case is an appeal judgment. So what happened is there was a matter before the Johannesburg High Court before Judge Valley, who handed down a decision which was then taken on appeal. And that was heard by a full bench. In other words, 3 judges, Judges Adams, Dippenaar, and Nyai of the Johannesburg High Court. And it's an interesting judgment which raises really 5 points that are worth debating, but I'll introduce them. I don't think we'll get to debate them today. The one is the sort of role of a court that isn't sitting as a criminal court in making decisions of fact which have criminal implications, which is a question that's popped up before, and I thought this full bench dealt with it quite nicely. Secondly, and this is a bit more for sort of legal nerds, especially counsel, if there are any in the audience, the Plascon-Evans rule and how evidence is adjudicated based on affidavits is dealt with in a little bit of detail in this matter, and it's worth having a look at if that interests you. The main thing that I wanted to focus on that really put this matter on the agenda was a finding on the nature of trustees' functionality as administrative action, which those of you who've been to the PLA for the last 2 or 3 years will know pops up with some frequency. The fourth point is really sort of a trite point, which is the phrase "fraud unravels all," and that has some implications for trustee decisions, which I think will be interesting to this audience. And finally, and I'll just say this point now, I won't deal with it in the course of the discussion, is that the High Court exercised jurisdiction to fire trustees. There was some argument about whether or not the High Court had that power when it was actually a regulatory function that resides with the regulator. And the court was persuaded that, on the facts before it, these guys just had to go. And the court declared them unfit to be trustees and ordered that they be removed from the board. So what happened? What led to these poor guys being removed as trustees? So the story is that some of you may know the Chemical Industries National Provident Fund is a sort of a sectoral fund. It was established in 1987, and what was regarded, probably the court gave it more relevance than I would have, is that it was established through the agency really of the administrator NBC, and that NBC had a very deep and long-standing relationship, having administered the CINPF for more than, about 30 years, from 1987 through to about the middle of 2019. Then what happened is during the course of 2019, it sort of came to a head in December 2019, actually. NBC's administration contract was terminated by the CINPF by resolution of the trustees, and NBC was not invited to bid for reappointment as administrator. And a new administrator, tenders were put out for new administration. There was a short list of 12, of which 9 were culled in the initial adjudication process, and ultimately 3 were invited to present to the board, one of whom was Akani. In the course of the presentations to the board, the 2 sort of competitors to Akani were removed from the process by the decision making of the board, with the result that Akani emerged, let's call it victorious, and Akani was awarded the administration contract, and NBC and a number of other people promptly took that decision on review and said, you know, something is rotten here. This is it's a setup. In fact, the allegation was, and it was in the mind of this court of appeal, certainly proved that it was a sort of an inside job by certain guys at NBC to have NBC removed to get themselves a little reward, and for Akani to then take over the administration. So by the time that all of this drama happened, the pre-court drama, the actual real life drama, there were about 21,000 to 22,000 members on the CINPF. NBC had invested a lot in walk-in centers nationally, which it sort of had established and maintained. But in the lead up to sort of November, December 2019, certainly the board's official version at the time was that NBC's fees were not market related, and that NBC had demonstrated a number of elements of poor service delivery. The court didn't decide on either of these points, so I must make that, you know, there was no finding by the court that NBC came short in any way, but the court said it wasn't necessary for it to delve into those questions. The more interesting question that the court had to delve into was that the board basically convened on the 27th of November a subcommittee to find a new administrator. The process of the shortlisting of 12, the elimination of 9, the 3 presentations, the disqualification of 2, and the resultant victory of Akani took place in the period from the 27th of November to the 11th of December. And I think most trustees on this call and administrators and anybody else, frankly, would really pat themselves on the back if they could get something of this nature initiated, processed, and concluded in a period of effectively almost exactly 2 weeks. What was even more interesting was that on the 20th of December, so about a week after the decision was made, the principal officer of the CINPF received 40,000 Rand as a funeral benefit. The chairperson of the CINPF received 25,000 Rand as a funeral benefit. The deputy chairperson received 25,000 Rand, and 2 senior employees, in fact, the key relationship managers of the CINPF, who were working at NBC, i.e. the guys who lost the deal, each received 50 and 40,000 Rand, also as funeral benefits. All of the funeral benefits arose from policies that were issued in August 2019 by Neighbor Funeral Scheme, which was an affiliate of Akani. Neighbor Funeral Scheme had the same shareholders and the same directors as Akani, no direct shareholding. But the court sort of looked at this a bit skiff, as they say, and wondered why all of these senior officials involved in the NBC relationship with the CINPF, received the bad news of deaths in their families, all in November or December 2019, and all relating to policies issued by an affiliate of Akani in the same month, being August 2019. The court, a quo, in other words, the court that originally heard this matter as a trial matter, said, look, it couldn't adjudicate on the validity of these payments because there were clearly sort of criminal suggestions here, and the matter was being investigated by the police. And interestingly, what this court said is that, and it's at paragraph 17 of the judgment, if anyone's interested, the court said a court cannot decline to hear evidence and decide a matter on the basis that the same issue is being investigated by other bodies. Now, that may surprise some people, but that is the law. It said a court can and should determine a material dispute before it, irrespective of whether that dispute is under investigation by another body or agency. And the courts of appeal therefore said that the issue of whether or not Akani bribed CINPF trustees, the PO and the CINPF, in order to procure its appointment was an issue that was squarely before the court of quo, in other words, the court below, and that it not only had the power, but it also had the duty to decide that question. And therefore, the appeal court took it up as a question that the appeal court needed to decide. It referred to a Nichols judgment, which said one of the primary functions of the court is to bring to finality the dispute before it. And it also referred to a judgment of acting Judge Wiener in a road accident fund matter, where it said, where the judge there said, the issues in any particular litigation are determined by the pleadings or the affidavits, and they may be expanded by the parties in the course of the proceedings. Once the case is settled, in other words, once it's clear from the pleadings what the case is that needs to be answered, then the court must adjudicate it. It is obliged to adjudicate it upon the issues it raises by rendering a judgment, unless the parties withdraw any of those issues. And one of the issues that the Court of Appeal felt was squarely before the Court of Quo in this case was whether or not these were in fact corrupt, unlawful and fraudulent payments. Now, I was going to put up a poll just for a bit of fun to see how many people agreed or could take a stab at what the Court of Appeal decided on the fact, but unfortunately I didn't get the poll functionality set up. And unsurprisingly to all, the court took the view that there was clearly corruption involved here, and there was clearly fraud. The court was partly informed by the fact that Neighbour Funeral Scheme was not an FSP. So how they even managed to place these funeral policies was a question that actually wasn't answered or in any way put before the court. So the court made the finding, and this appears at paragraphs 34 and 35, and I just wanted to use the words of the court to say that the versions of CINPF and Akani can and should be rejected on the papers. So this is coming to the question of evidence that I raised at the start. They are inherently contradictory, vague, and or implausible. There's no need for any disputed issue to be referred to oral evidence, which was one of the contentions. No explanation offered in the is offered in the affidavits why these remarkable coincidences are plausible. This is a clear, no, I'm not quoting anymore. The court then said this is a clear example of fabrication. The payments were corrupt. They constituted bribes, and the termination of NBC services is therefore tainted with fraud and corruption. And then the court said these disputes of fact fall squarely into the category of nominal factual disputes that can and should be resolved on the paper. The explanations are so far-fetched, clearly untenable, and the court is justified in rejecting them on the papers. The explanations consist of nothing more than bald or uncreditworthy denials, which raises fictitious disputes of fact, are palpably implausible, far-fetched, or so clearly untenable that the court is justified in rejecting them on the papers. And interestingly, some of the wording the court used there is from a previous judgment called NDPP versus Zuma, 2009. So I think we've learned some lessons about corruption, and the Court of Appeal in this case didn't hesitate to apply them. So there's some, as I said, for the law nerds, there's some interesting stuff there about the question of evidence, which isn't oral evidence, which isn't tested in cross-examination. But it's clear that the courts will no longer hesitate to dismiss bald allegations, which simply really kick up dust, as opposed to well-reasoned explanations of why a set of facts that looks a little bit odd, quite frankly, may in fact have some plausibility. So it's quite a bold position for a court of appeal to take, and maybe it'll be challenged. But be that as it may, it does draw quite a line in the sand for people who think they can get away with affidavits that don't really give a full and convincing story. The main point that we also wanted to discuss here is at paragraph 40 and onwards in the judgment. The court says, as correctly contended by counsel, a pension fund is a private institution which may exercise public power in certain circumstances, and the conduct of the fund may sometimes be challenged as constituting administrative action, either as defined under the Promotion of Administrative Justice Act or under the common law. The court said, and I'm glad they said this because the rest of the judgment gets a little bit sort of out of hand in my view, in a very clear sentence, not all decisions of a pension fund constitute administrative action. However, what the court said in this case is that we are of the view that the power of the trustees to delegate their statutory obligation to properly administer a pension fund to an administrator, that power being both empowered and circumscribed by legislation, is a decision which involves the exercise of public power or the exercise of a public function. And this is so because, considering the definition of administrative action in PAJA, the pension fund exercises such power in terms of an empowering provision, being the PFA and the regulations thereunder. And on the basis of that, the court found that the decisions also have a direct external legal effect and affect the rights of members. And accordingly, the court found that it is of the view that the decisions sought to be reviewed, those are the resolutions of the trustees, and set aside in the review application, and they constitute administrative action as defined in section 1 of PAJA. So this was the part that caused me to first raise my eyebrows, is I'm not sure that that this is, in fact, that the appointment of an administrator is the exercise of administrative power. But if it is, it raises all kinds of questions about how one can go about that, whether administrators who are not appointed can raise questions which demand a reply within 90 days under PAJA, et cetera, et cetera. My own view is that this is not administrative action. Sections 7 through to all of the amended sections, section 7A, B, C, D, E, and F of the Pension Funds Act contains no empowerment or obligation of trustees to appoint administrators. It's true that most funds are externally administered, but that's a contractual issue based on capacity and skill and expertise. It's not a duty. On the contrary, sections 8, sections 9, section 9A of the Pension Funds Act do oblige trustees to appoint principal officers, auditors, and in relevant circumstances, valuators. So there is a duty. Secondly, section 13B does not circumscribe the power of the trustees to appoint administrators. It says that anybody who wants to be an administrator can't be an administrator unless they've been approved. In other words, the obligations there lie on the administrator, not on the trustees. And of course, we often forget this, but section 13B doesn't contemplate all of the functions that one typically sees in a modern pension fund administration system. It only talks about the FSCA approving a party who wants to administer the receipt of contributions or the disposal of benefits. So those two functions, the taking in, the calculating of, and the paying out of monies, are really what section 13B seeks to regulate. So I must admit, a little bit concerned that maybe the facts of this case caused a decision around administrative action, which may be a little bit ambitious. That's a personal view. I haven't spoken to the counsel involved in the case. I haven't spoken to the judges. I'm not aware whether the matter will go on appeal to the Supreme Court of Appeal or any other place. But in any event, those are some of the concerns and questions that I had about this finding. The other point is that the court says there's a direct external legal effect in that the judgment, that the decisions of the trustees in terminating the one administrator and appointing a new administrator affects the rights of members. But the rights of members are not a consequence of a direct and external legal effect. You know, in the case of, so I've just lost my place here. But anyway, there is a case which deals with 37C, for example, where the court said that, I think it was TT, the TT versus funds at work. It said that, you know, the impact in relation to 37C is on members of the public because the member of the fund dies and the beneficiaries could be any number of people depending on how the 37C analysis pans out. However, in this case, the administration of the fund has a direct effect only on the members of the fund, not on the public at large. So I think that may have been, with respect, a bit of a misapplication of the TT judgment as well. Finally, the court referred to a judgment of Lord Denning, which basically says, regardless of whether this is Padger, well, Denning didn't say this. The court said, regardless of whether this is Padger or anything else, the very short answer here is that fraud unravels everything. This has been stated by our SCA on more than one occasion. It comes from an old English case, and it is now tried law that because of the fraud and the bribery, the decision to terminate NBC's contract, as well as the decision to appoint a Carney and various other service providers, is invalid ab initio. Also, all of the resolutions of the trustees that were taken to that effect are void and of no effect, because the court said, when the board makes a decision, this is paragraph 57, when the board makes a decision to terminate the appointment of an administrator, it acts not in its own interest, but in the interest of the fund. It and each member of the board is obliged to act in accordance with their fiduciary duties and the duties to act with due diligence, independence, and impartiality. Where the chairperson or deputy chairperson are conflicted by having accepted or agreed to accept payment of a bribe in order to pave the way for Akani's appointment, both they and the board as a decision-making body are fatally compromised. So my time is up, so I'm not going to expand on that any further, but I think the point has hopefully landed, that fraud is fatal. Corruption, bribery are fatal to the decision-making processes that they seek to effect. And therefore, what happened here was that obviously those were all set aside, and Akani was disappointed as the administrator as a consequence. And of course, as I said right at the start, the two trustees were dismissed by the Court of Appeal as part of this judgment. So that is my presentation. Graham's presentation has slightly less time available. I see one question has arisen, Graham. I'm just going to have a quick check. Can you share the slides? Yes, we will. I will answer that after Graham has spoken. All of our slides will be available as well as any cases we refer to, but we'll just do some housekeeping there as to whom you can request them from and how we know who wants what, but we'll chat to that at the end. Okay, so thank you for that. I will now hand over to Graham, who you can see, and who will take you through the case, the Living Hands case. Thanks, Graham.
Thank you, David. Right, morning, everybody. David, at least you're not a cat and we can't see you, so it's preferable to that. But I'm going to talk to you about the Living Hands Umbrella Trust case versus Old Mutual. It's a case that involves the notorious J. Arthur Brown and Fidentia, which all of you will have read about in the past. And I'm also going to try and explain why I think it's relevant to the pension fund industry as well. So I'm just going to take you through the background first. And then just through the law and the conclusion that was reached by the court. In terms of the parties, the plaintiff was the Living Hands Umbrella Trust. Now, the Living Hands Umbrella Trust was an umbrella trust that was established in the sort of early days prior to beneficiary funds being created to cater for the death benefits of minor beneficiaries of pension funds. So you all know that if you're dealing with a minor beneficiary, you now very often send their monies over to a beneficiary fund. But prior to beneficiary funds, you would send it over to an umbrella trust, and the Living Hands Umbrella Trust was one such trust. It was established largely to receive the benefits of employees employed in the mining industry. So these are generally fairly vulnerable minor beneficiaries that were all over Africa, basically. It was administered by a company called Matco, which was its appointed administrator, and obviously it had established the trust. And they appointed Old Mutual as their investment advisor, and the monies were accordingly invested in collective investment schemes, all with Old Mutual. And that arrangement had lasted for many years, and it was a very, very successful arrangement. What then happened was that old J. Arthur Brown and Fidentia purchased Matco, and so they got their hands on the administrator. And having got their hands on the administrator, they then appointed some very compliant trustees that would do their biddings to be the trustees of the Living Hands Umbrella Trust. They acquired a small asset management company. It was a very small company that was basically a father and son outfit that was sort of doing broking, but they then got it relicensed as an investment advisor and asset manager. Having acquired this investment management company, they then appointed it as the new investment advisor to the trust. And they hadn't given notice to Old Mutual on their SLA, which required a 90-day notice. But the first thing that the new asset manager did was write a letter to Old Mutual and saying, we want you please to liquidate 150 million rand of your funds, and we want you to pay it over to a bank account which they nominated. Now, there were a couple of things about that letter. Well, first, the first thing is that Old Mutual had never dealt with these people before. They'd never been introduced to the new trustees and new managers. They didn't know that they were actually being fired, and they didn't know why they were suddenly being asked to pay 150 million rand, where ordinarily they were paying small amounts out to beneficiaries and liquidating small amounts. And they were being asked to pay to a bank account that was not the trust fund's bank account. So Old Mutual balked at paying this, and correctly so. They said, well, we can't pay on this instruction. What then happened was that the asset manager then upped the ante on Old Mutual, and they started making statements that you're acting outside an investment mandate. You don't have an investment mandate. They started alleging irregularities. And they basically said, look, we are now calling up the whole investment of over a billion rand, and we want that liquidated in one day and paid out. And this time they gave the correct trust account number. And, and they established that they'd been appointed as the investment advisor. The service level agreement said that if notice was given to liquidate, they would have at least 5 days in order to do the liquidation, but they were now being asked to liquidate immediately. But at this point, Old Mutual capitulated to the pressure, and they liquidated the portfolio within 2 days, and they paid the money back over to the trust account's bank account. Now, from any ordinary asset manager's perspective, you would have thought, well, I've discharged my mandate, I was given notice to liquidate, I've liquidated the portfolio, and I've paid it back to my client. That's the end of my involvement in this matter. I've discharged my mandate, and I'm not really particularly interested in what happens thereafter. And that, I think, most investment managers would have had that attitude prior to this particular decision. We all know that what then happened was that once J. Arthur Brown had got his hands on this money, he went on a spending spree, and he bought a spa and wine farm for his wife to run. They bought game farms. They paid the purchase price for Matco, which was about 150 million, which is presumably what the first 150 million was required for. And they otherwise dissipated all of the funds in running Fidentia. And ultimately there was about 860 odd million rand that was lost by J. Arthur Brown and his cronies. Now, the surprising thing that next happened was that Living Hands Umbrella Trust sued Old Mutual for the loss of this 860 million rand, and they sued them in delict, and they said your negligence in handing over the money in the manner that you did has caused this 860 million rand. And there are a couple of arguments that they said, is that first of all, when you got that instruction for 150 million rand from people you'd never heard of, from an asset manager that nobody had ever heard of, to pay it over to a bank account that you didn't know about, that should have immediately put you on high alert. And in fact, you should have gone and reported it at that point in time, because you had a reporting obligation, and this was highly suspicious activity. And had you reported it at this very early stage, none of the events that would subsequently unravel would have unraveled, and we wouldn't have lost the 860 million rand. That's the essence of the argument. Now, what the court did is that it looked at the entire regulatory framework that governs asset managers and trusts. And it says, you've got the Trust Property Control Act, you've got the Protection of Funds, Investment of Funds Act, which imposes a whole lot of duties. You've got the Collective Investment Schemes Act, which regulates investments, and all of those have very onerous obligations in relation to trust monies. And essentially, arising out of that, they said that all of those acts are there in order to protect vulnerable people. And they essentially said, arising from that framework of legislation, there's obviously a duty of care, and they said that duty of care is owed to the beneficiaries of the trust and the trust. And it didn't matter that the service level agreement and contract was between Matco and Old Mutual, because the duty of care created by that legal framework trumped any contract. And essentially, arising out of that duty of care, they said, you've got to then basically be very, very careful in how you handle that money. They then said, if you look at the investment mandate, they say that that duty of care covers the entire investment chain. It covers from when you get the money to how you invest the money. It doesn't only apply to the investment money. It also goes to your discharge at the end of the tenure. When you discharge your mandate, that duty of care applies all the way through, even to the discharge of the mandate. And that, I think, would be the part that would surprise most people, because I think most people would say, well, I'm fired, I'm terminated, I'm handing back my money to my client as instructed by them. I don't have any duty beyond that to give back the money in terms of my mandate. But the court said, no, it goes further. You've got to satisfy yourself about the new manager, and that the new manager is going to safeguard that property and is going to do it prudently and honestly. Now, that is pretty far-reaching stuff for investment managers. They said on the facts, Old Mutual should have been concerned the moment it got that instruction for the 150 million rand. It should have never balked at the pressure that was being placed on it with allegations of irregularities and the like. It should have insisted on the 90-day notice that that the SLA provided for to be given notice. It should have insisted on the 5 days to liquidate, and the entire haste and the fact that they only started to FAM after they'd already paid the money indicated that they'd failed in that last part of discharging their mandate in a safe way to safeguard the interests of the trustees. Now, I mean, it's a very surprising case in terms of its outcome, is that you would never think that an old investment manager who's been terminated would be held liable for the new investment managers and trustees dissipating and stealing all of the money. It seems such an improbable outcome. And in terms of the delictual tests, it does seem a very improbable outcome of causation, foreseeability, all of those kind of issues do seem highly improbable. That the court came to the result that it did was that Old Mutual has to compensate the umbrella fund for 860 million rand plus interest, which is going to run into a significant number in the billions. So it's a very surprising outcome in delict. And no doubt we've not seen the end of this matter. It's going to go on appeal. But you may ask yourself, well, what is the relevance of all of this to the pension industry? And the relevance is this, is that the same regulatory framework largely governs your, as a pension fund, it largely regulates it as well. So the collective investment schemes, obviously, if you're invested in unit trust, that same legislation applies. FAIS applies. The Financial Institution Protection of Funds Act, that also applies. The only difference is the Trust Property Control Act doesn't apply, but the Pension Fund Act does. And the Pension Fund Act creates probably even more onerous obligations in terms of the duties of care and all of those kind of things than the Trust Control Property Act did. So the same regulatory environment applies. So an asset manager now being terminated by a pension fund would arguably owe that same duty of care. And assuming that this judgment is correct, and there's clearly a lot more debate that has got to be held regarding it, that asset manager is going to be asking questions about, well, who am I? Why is this being terminated? Where is this money going to go? Which asset manager is it? And performing some form of limited due diligence to see whether it's an established and well-known asset manager or just some fly-by-night that's just been registered. So very interesting case, very interesting outcome, surprising outcome. No doubt we've not seen the last of it. I can't see Old Mutual not taking this further. So yeah, thank you. That's me. I think
Thanks,
Deirdre
Graham.
is going to hand over to you. I think you're dealing with the next of the cases.
Yes, I'm just going to try and share my screen once again. Just tell me that you can see it.
We can see it.
Okay, cool. So thanks for that, Graham. In the last 20 odd minutes, I just want to discuss two more interesting cases. They so happen to be both from the cases that relate to the Municipal Employees Pension Fund. So I'll go straight into it. So the first one relates to the MEPF versus Medal and the adjudicator. It's a SCA case, a very recent one, April 2020, where it basically relates to the retroactive amendment of fund rules to reduce a member's withdrawal benefit. So briefly, and the facts of this matter is quite important, as well as the timeline. So Mr. Bouwer, which I'll just call the member, was employed by the municipality, and by virtue of his employment contract, he had to become a member of the MEPF, and he was a member since 2003. He resigned from employment on the 31st of May 2013, and in terms of the rules, he would have then been entitled to withdrawal benefit. The rules provided that a member who joined the fund after June 1998, which was applicable to this member, would be entitled to a withdrawal benefit calculated as follows: the member's contribution plus the interest on that amount multiplied by 3. So that's what the rules provided. However, the fund's actuary advised the fund that these are quite high rules, and may, or quite a preferable benefit, and it may be unsustainable for the financial future of the fund. It may become financially unsound, and therefore the trustees would need to rethink of amending that rule. So the board acted upon the advice received from the actuary and resolved on the 21st of June 2013, i.e. just like a month or so after the member resigned, to amend its rules with retroactive effect to 1 April 2013. This amended rule then provided that a withdrawal benefit will be calculated on the same basis, except it will be multiplied by 1.5 as opposed to the previous 3. So They advised in the reason for the amendment that it was a risk to the fund's solvency and that they want to prevent a run on the fund, meaning that they are preventing members from resigning and tapping into a higher withdrawal benefit, or would receive a higher withdrawal benefit. The fund then submitted the rule amendment to the FSCA, the registrar, who approved the rules on the 1st of April 2014 with retroactive effect to 1 April 2013 as the board resolved. The member was paid his withdrawal benefit on the 18th of October 2013, but he was paid his benefit in terms of the amended rule. Now, the amended rule was not yet approved by the registrar at the time he received his benefit, because as I've stated, the registrar only approved the rule on the 1st of April 2014, although it had retroactive effect to the 1st of April 2013. But as I've mentioned earlier, the member resigned from employment on the 13th of May 2013. So the rules that applied to him at the time were the old rules, not the amended rules yet. So naturally, the member was quite upset that he had received a reduced withdrawal benefit, and he lodged a complaint with the adjudicator, claiming that his benefit should have been calculated based on the rule that applied to him at the time he resigned, which was the 3 times, not the 1.5 times. The adjudicator found in his favor and said the fund should pay him a benefit in terms of the rules that apply to him. And the rule amendment wasn't approved by the registrar at the time, and therefore they acted upon a rule that wasn't, of any force. The MEPF was not satisfied by that outcome, and then they lodged an appeal and then a review. It was quite strange how that worked, but in any event, it was before the High Court, and argued that the adjudicator's determination was ultra vires her powers. But the High Court upheld the determination and said that the adjudicator was right, that the benefit should have been calculated in terms of the rules that applied to the member at the time, not the amended rule. Not being satisfied, the MEPF then went to the SCA, lodged an appeal before the SCA, and the grounds were that the complaint fell outside the adjudicator's powers because it doesn't fall within the definition of complaint. Remember that the complaint was that about the interpretation of the rules that applied to him at the time. And the MEPF also complained that the adjudicator erred in finding that the amended rule could not be applied to his withdrawal benefit, which accrued before it came into effect on the 1st of April 2014. So the SCA then, on the first point on whether the adjudicator had jurisdiction, found that no, her office did have jurisdiction, and it related to the interpretation of the rules, and therefore falls squarely within the definition of complaint and complainant. So on that ground, the SCA agreed with the adjudicator, but and why I'm discussing this case today is the findings in relation to the retroactive rule amendment. The SCA basically found that, or set aside the adjudicator's determination and ordered that the fund was entitled to pay Mr. M his benefit based on the rules, based on the reduced withdrawal benefit rule. So in the judgment, which you can read, the SCA unpacks section 12 of the Pension Funds Act. And as we know, that deals with the powers of a board to amend the rules. And section 12 says that, of course, the board has the power to do so, depending on what the rules allow with amendments. But that rule amendment must not affect any right of a creditor other than a member or shareholder of the fund. And of course, the registrar must satisfy himself that that rule amendment will not make the fund financially unsound. And as we know, and as has been in many, many cases before this SCA case, a rule only takes effect once the registrar has approved the rule. So the court, considering section 12 and considering the rules of the fund, which allowed the board to amend the rules, found that the board, the fund was entitled to pay the member this reduced benefit. But what I found important to discuss today, and I've quoted it here, is what the court said at paragraph 21 and 22 of the judgment. The judge said, to my mind, the plain and ambiguous language of the amended rules simply does not brook this contended construction, i.e. that it can only apply on the date it was approved. The amended rule explicitly states that it operates retroactively and thus reduces pension benefits due to members with effect from the 1st of April 2013. In my view, there can hardly be a clearer indication of an intention to interfere with existing rights with effect from that date. As I've mentioned earlier, there were no statutory impediments on the registrar approving and registering a rule which sought to impair rights that accrued before its registration. The court then went on to say that I consequently conclude that the amended rule retroactively applied to all pension withdrawal benefits which had accrued to the fund's members as members after the 1st of April 2013. However unfortunate this finding may be for Mr. Medal, the amended rule thus also applies to his withdrawal benefit, and accordingly the SCA found that the appeal must succeed. I mean, this is groundbreaking stuff in my view, because we've always known and understood that you can't interfere with accrued rights. And as I've mentioned, the timing is important, because the rule that applied to this member at the date he resigned was the rule that was approved. That was the rule that was legally in force, which said 3 times, not 1.5 times. But it appears that, and maybe this is the little trick here, the difference between a retroactive amendment and a retrospective amendment. And I would have liked to see the actual board resolution whether it specifically dealt with retroactive or retrospective, if that had that wording, because we know that in law, there's actually a difference between a retroactive and a retrospective amendment. And just to remind you, retroactive is a statute which operates as of a time prior to its enactment. So it operates backwards, where a retrospective amendment is one that operates for future only, but imposes new results in respect of a past event, and it operates forward. The vast majority of amendments we see, a rule amendment can have retrospective effect. For example, it can say with effect from the 1st of April 2013, this will apply. But the important here is where a member's benefit, a member's right has already accrued based on the rules that applied at that specific event. The day he resigned is the day he became entitled to withdrawal benefit. It was immediately then due and payable for all intents and purposes, and that's the rule that should have applied. So how the SCA, in my view, could have found with respect that this member was entitled to a reduced benefit based on a rule which was not approved by the registrar at the time, it has far-reaching consequences. I'm not aware that this case will be appealed. I doubt that the member has, sufficient funds to take it on appeal, and I don't think it was. But it raises important questions of, retrospectivity and retroactive amendments, and that, that although a member may think that they will be entitled to a benefit as currently worded, there's nothing then prevented, based on this case, on trustees to amend the rules and basically to reduce your benefit. It's a quite interesting, cumbersome judgment, but it is what it is then currently, unless a court or the Con Court finds differently. The second case I want to briefly discuss in the last few minutes we have is the MEPF. Again, I'm not picking on the fund, it's just it so happens to be 2 cases of the same fund in the same year. This is a constitutional court case, and it relates to the definition of complainant and complaint, where a member thought, or a person thought he or she was a member of a fund, but wasn't necessarily. So briefly, Ms. Wongwa Kwatse was employed by the municipality as its chief audit executive in February 2012. Her employment contract was for a fixed term period for 5 years. When she was onboarded as an employee for the 5 years, she completed the application form with the employer. It was stated that she will pay the contributions will be 7.5% by her and 22% by the employer, and that would be deducted from her pensionable salary. Interestingly, this form that was submitted didn't state, or didn't have a box or require the member or the employee to state whether it's a fixed term employee, a permanent employee, a contract worker, none of that. And the form also didn't have a box or require input on the member's employment status. So the form was completed. There was an agreement on the 7.5% and 22% that would be paid. And this was included in her remuneration package, inclusive of all benefits, and was deducted from her salary. So then in November 2014, the fund sent her a member benefit statement, which then said her benefit would only be calculated based on the 7.5% contribution. Of course, she queried this because 22% and the 7.5% was deducted from her salary. And this is the first time in 2014 where she realized that the rules actually did not, or where she learned that the rules actually did not allow fixed term employees, as she was for a 5-year period, to be a member of a fund. So she then discussed this with the employer. The employer also notified the fund and said, please return the contributions. They were paid in error. Oops, sorry, she wasn't actually eligible to be a member of the fund. And the fund turned around and said, well, no, sorry. I mean, that's, her benefit will be paid on the 7.5%. The 22% we use as a fund to cover costs and expenses, and we've it's part of our reserve account, so we'll hold on to that part. It won't be paid. So they basically refused. Again, naturally, the member, or Ms. M, then lodged complaint with the OPFA and said essentially that the rules did not permit her to be eligible as a member of the fund. The fund only paid her about 230,000 of the withdrawal benefit, whereas it should have been around 850,000, and requested that the fund return the contributions to her. The adjudicator found in her favor and said that yes, no, she wasn't entitled to be a member based on the rules. She funded the 7.5% and the 22% contribution. That amount was deducted from her salary, and therefore that should be returned to her with interest, and the fund was unjustly enriched, and upheld the complaint. The MEPF again wasn't satisfied with that outcome, lodged a review application with the High Court. The High Court dismissed the application on similar grounds as the adjudicator, but interestingly, in the submissions before the High Court, the MEPF said that the adjudicator didn't have jurisdiction to entertain the complaint because the member alleges that she's not a member. So she's not a complainant for purposes of the jurisdiction before the adjudicator. There's therefore no complaint, and the adjudicator couldn't have entertained this matter. The High Court also rejected that and basically dismissed the application. The MEPF wasn't satisfied with that and then went to the SCA, who also dismissed the appeal. Thankfully, the MEPF, I think being very litigious, wasn't happy with that, and that outcome, satisfied with that outcome, and appealed to the Constitutional Court. And the Constitutional Court then, went through the motions, unpacked it, first decided at the starting point who qualifies as a member. It's an employee, but there's certain exclusions. One of those exclusions would be a person that's employed on a part-time basis or for a limited period. It's clear, it's not disputed that this employee was only appointed for a 5-year period, so it's a limited period, and therefore did not, based on the rules, qualify to be a member. And the Con Court also found that she should be, the contributions that were paid to the fund should be returned. But importantly, and I think this is one of the takeaways I'll discuss, is that the Constitutional Court actually reminds us that the qualification, and I've bolded it, that the qualification for membership is a fundamental component of pension fund governance. The court then also basically found that the fund was unjustly enriched and that everything should be repaid to her. The take home of this is I find it interesting that it's very clear when you read the rules that she didn't qualify as a member. The contributions that were paid were clearly made in error. If a fund holds onto those contributions, the requirements for unjust enrichment would obviously apply, and they had to repay that. On the fact of on the allegations that the adjudicator didn't have jurisdiction, the court, I didn't quote it here, but please go and read it. It is the first Constitutional Court case that very nicely and crisply unpacks the definition of a complaint and a complainant, and has read a bit more into what that means. And essentially, my interpretation of that is that where it has to do with the fund and has to do with the rules, you shouldn't give it a very narrow, you shouldn't define the definition of complaint or complainant narrowly. The Constitutional Court refers to it should be a wider interpretation in the interest of justice, and therefore, agreed that it was a complaint and she was a complainant. Further takeaways from this is that funds must not blindly accept contributions. You need to check whether the person is in fact eligible for membership in terms of the rules. Maybe perhaps think of forms, and also, the duty on the employer. An employee should also be aware of what the rules say in relation to eligibility. All of this could have been prevented had the member or the employer or the employee and the employer just checked the rules in relation to eligibility, where it was clearly stated limited period, employees aren't permitted to join the fund. And then I'm thinking, whether the trustees will be able to place an obligation on the employer to check and to ensure that prior to the employer forcing an employee to be a member of a fund, that the person is actually eligible to be a member of the fund. And the last point that I just want to make, and I think it's also something that we may, or some employers may have forgotten, is that the whole issue about on a probation period. We know that many of the employment contracts say that an employee will be appointed for a 3-month probation period, for example. But as soon as you employed, unless stated otherwise, you become a permanent employee. So it's from day dot, it's from the first day that depending on the rules of the fund, that you must, that you qualify for these benefits. The fact that you may be on a probation period doesn't necessarily mean that there's no obligation on the employer to ensure that the member is enrolled on the fund, or the employee is enrolled on the fund or the medical scheme. So these are two cases I just wish to discuss today. I haven't checked the chat function. I see I'm asked to. What is the question here? So the repayment of the group contributions was done without tax, but with investment interest. Herbert, I assume that it was. I don't have those details. I think it was the total 800 whatever thousand benefit that had to be repaid, if you're talking about that case. But again, as I've mentioned, it's two interesting cases of a very litigious, it appears, fund, where I don't think none of these cases should have gone as far as they should have in the first place. We have run out of time, unless there's one or two more questions that somebody wants to pose in the Q&A. I'll just give it a minute or two, but we'd like to thank all of you that have took the time to attend our Breakfast with Benefits session this morning. I hope it was useful. I hope it gives you a few takeaways and things to think of. Yes, thank you very much.
Thanks for attending, and cheers.
Yes, thanks everyone. Bye-bye.
Thanks all. Bye-bye.